Okay, we're live in corporate combinations, tender offers, and defending control, chapter 14, section 1 on small scale merger, talking about the short form first and then small scale merger. But it's important, I guess, to classify these as statutory merger procedures. And might as well give the definition of statutory merger is a fusion of two constituent corporations pursuant to a formal agreement executed with reference to specific statutory merger provisions, under which one corporate survivor succeeds to the assets and liabilities of the other corporation by operation of law. A consolidation is the same, except they form a new organization. And I'm going to start with like a short article and then go into short form mergers. So this is by E. Welch and A. Turizon II and R. Saunders Folk on the Delaware General Corporation Law, section 251.2.2.1 from 2006 in the Fifth Circuit, I think, and the requirement of the Delaware section 251F that the survivor certificate of incorporation not be amended is designed to assure that the merger technique cannot be used to deprive stockholders of the voting rights that they would enjoy if the certificate were being amended under Section 242. Secondarily, the theory underlying... Sorry, I'm just going too fast. 251 is designed to assure that the merger technique cannot be used to deprive shareholders of voting rights that they would enjoy if the certificate were being amended. And the theory underlying it is a 20% limitation on increasing the number of common shares is that a merger that involves less than 20% of the survivor shares is not such a major change as to require stockholder vote and is really no more than an enlargement of the business that could be achieved by other means without triggering voting rights. For instance, a corporation purchasing assets need not secure approval of the stockholders to issue already authorized shares to the seller. Nor would voting rights exist if a corporation offered its own authorized shares in exchange for the shares of another corporation and thereby gain control. Or if the corporation were to sell its authorized shares for cash and then use the proceeds of the sale to purchase assets. When business needs demand that the acquisition take the form of merger rather than purchase of assets or shares, the premise of the statute is that the merger should not require a stockholder vote when other procedures with nearly identical economic consequences do not require a stockholder vote. Stated otherwise, Section 251F puts mergers more on parity with acquisition of assets or shares so long as the legal requirements are concerned. So we're citing Section 253 now of the Delaware Corporate Law and the Model Business Corporation Act 11.05, and starting with the short form mergers. Corporate statutes include provisions authorizing the so-called short form merger, under which certain parent-subsidiary mergers can be effected simply by the parent's board, that is, without a vote of the parents or the subsidiary's shareholders, without appraisal rights in the parent's shareholders, and frequently without a vote of the subsidiary's board. Most of the early short-form statutes were inapplicable only to mergers involving a parent and its 100% owned subsidiary, and were probably conceived as procedural in nature, designed to simplify the mechanics of mergers. However, today, the reach of short-form merger provisions has been substantively extended in two important ways. First, many of such provisions are now applicable to mergers between parents and less than 100% owned subsidiaries. Typically, although not invariably, the floor is set at 90%. Second, it has been held that the Purpose of the statute is to provide a parent corporation with means of eliminating the minority shareholder interest in the enterprise by issuing cash rather than stock to the minority. See Beloff versus Consolidated Edison Co., New York, 1949. To the extent this view is followed, these statutory provisions operate as cash out rather than merger statutes. So, moving on to the next section. Oh, wait, no. Furthermore, there are cash-out statutes that run in one direction only. The parent can force the minority to sell at any time, but the minority cannot force the parent to buy. Okay, so D, the stock modes and the de facto merger theory. And we're going to go into this for a short period before reading the first case. Having considered the traditional form of combination mergers, we now pass the consideration of two newer modes of corporate combinations: stock for assets combinations and stock for stock combinations. In a stock for assets combination, Corporation A issues shares of its own stock to Corporation B in exchange for substantially all of B's assets. Often in such a combination, Corporation A Often in such a combination, A agrees to assume B's liabilities. In some instances, however, A may assume B's liabilities only on a selective basis. Indeed, however, A may the reason for using this mode of preference is a preference to a statutory merger may be A's desire to avoid assuming all of B's liabilities. Usually, B agrees that upon completion of the exchange, it will dissolve and distribute its stock in A to its own shareholders. So that's sort of the definition. The reason for this is that A does not want a large block of its stock concentrated in a single holder. Frequently, it is also agreed or understood that some or all of B's officers and directors will join A's management. In a stock-for-stock combination, Corporation A issues shares of its own stock directly to the shareholders of Corporation B in exchange for an amount of B stock, normally at least a majority sufficient to carry control. By virtue of such combination, the shareholder groups of the two corporations are combined to a substantial extent, and B becomes a subsidiary of A. Frequently, B is then liquidated or merged into A, but whether or not this occurs, B's assets will be placed under A's control. Such a combination does not require approval by B's management, since the corporate action by B is not required. However, often the terms of the exchange of stock are worked out beforehand by the managements of both corporations, and often too is agreed or understood that some or all of B's management will stay on with B in its new role as a subsidiary or will join Corporation A itself. There has been a sharp division of opinion on the issue of how to characterize such combinations. Take, for example, a stock for assets combination in which A acquires substantially all the assets of B in exchange for A's common stock. A assumes all of B's liabilities, and B agrees to dissolve and to distribute to its shareholders the A common stock it receives. One possible way to review such a combination is as a de facto merger, which we're going to talk about in not the next case, but the case after that case. So with time, I'll get it into this recording. Other case on this is Rath versus Rath, Pack & Co. If the combination is viewed as a de facto merger, then in the normal case, that is, in the absence of some special exception, it requires a vote of both A's shareholders and B's shareholders and triggers appraisal rights in both A's shareholders and B's shareholders. Okay, so that's your de facto requirements. Some strict comparatively. Alternatively, the transaction could be characterized as a purchase by A and a sale of substantially all assets by B. That is the position taken in Harrington, which we're about to read, and Hellebron versus Sun Packing Co. Infra. Under traditional corporate statutes, a purchase does not require shareholder approval and does not trigger appraisal rights. Therefore, if the combination is treated as a purchase by A, it neither requires a vote of A shareholders nor triggers appraisal rights for the shareholders, although it would have required a shareholder vote and triggered appraisal rights if it had been characterized as a merger. I think B, what's not being said here is that B shareholders have to be informed because substantially all of their assets are being sold. Maybe I'm wrong because it doesn't say it. No, I lied. Next paragraph. Now we turn to B's shareholders under the corporate statutes. A sale of substantially all assets, unlike a purchase, does require shareholder approval. Therefore, the combination will require the approval of B's shareholders. Okay. Furthermore, most statutes provide that if a corporation sells substantially all of its assets, the transaction triggers appraisal rights in the corporation's shareholders. Therefore, B's shareholders, unlike A shareholders, will usually have appraisal rights. However, under some statutes, most notably the Delaware statute, the sale of substantially all assets does not trigger appraisal rights. Under such statutes, if a stock for assets combination is treated as a purchase by A and a sale by B rather than a merger of A and B, B's shareholders will not have appraisal rights, although they would have had appraisal rights if the transaction had been characterized as a merger. The first case is from the Supreme Court of Delaware called Harrington versus Arco Electronics, Inc. from 1963. Sutherland is the Chief Justice, giving the majority opinion. This case involves the sale of assets under Section 271 of the Corporation Law 8 Title 8 Delaware Code. It presents for decision the question. So the facts are there's a sale of assets. Here's the issue. A sale of assets is, and it's like, I don't know, it's citing the Hellebron case that we just talked about. So the issue may be stated as follows. A sale of assets is effected under Section 271 in consideration of shares of stock of the purchasing corporation. The agreement of sale embodies also a plan to dissolve the selling corporation, distribute the shares so received to stockholders of the seller so as to accomplish the same result as would be accomplished by a merger of the seller into the purchaser. Is the sale legal? Then Arco and Laurel Electronics Corp. And your corporation are both engaged in somewhat different forms in the electronic equipment business. In the summer of 1961, they negotiated for an amalgamation of the companies. As of October 27, 1961, they entered into a reorganization agreement and plan. The provisions of this plan pertinent here are in substance as follows. Arco agrees to sell its assets to Laurel in consideration and alia, issuance of it to it of 283,000 shares of Laurel. Arco agrees to call a shareholders meeting for the purpose of approving the plan and the voluntary dissolution. Arco agrees to distribute to its stockholders all of the Laurel shares received by it as a part of the complete liquidation of Arco. The Arco meeting, all of the stockholders voting, about 80% approved the plan. It was thereafter consummated. Plaintiff and stockholders did not vote in the meeting, sued to enjoin the consummation of the plan on the grounds that it was illegal and that it was unfair. And the second ground was abandoned. Affidavits and documentary evidence were filed, and defendant moved for summary judgment and dismissal of the complaint. The vice chancellor granted the motion and plaintiff appeals. The question before us, as we stated above, plaintiff's argument is the sale is illegal and runs as follows. The several steps taken here accomplish the same result as a merger of Arco into Laurel. In a true sale of assets, the stockholder of the seller retains the right to elect whether the selling company shall continue as a holding company. Moreover, the stockholder of the selling company is forced to accept an investment in a new enterprise without the right of appraisal granted under the merger statute. Section 271 cannot therefore be legally combined with a dissolution proceeding under 275 and a consequent distribution of the purchaser stock. Such a proceeding is a misuse of the power granted under 271 and a de facto merger results. And if we remember what de facto was, it involves the approval of both companies' stockholders, I believe. So the foregoing is a brief summary of plaintiff's contention. What we do figure out here is that the court affirms. And so far, all we know is that there was a motion for summary judgment. So they might affirm that. But let's read on. For the plaintiff's contention that this sale has achieved the same result as a merger is plainly correct. The same contention was made to us in Hellebrand Sun Chemical Corp. Accepting it as correct, we noted that this result is made possible by the overlapping scope of the merger statute in Section 271 mentioned in Sterling v. Mayflower Hotel Corp. We are also adverted to the increased use in connection with the corporate reorganization plans of 271 instead of the merger statutes. We observe that no Delaware case has held such procedure to be improper, and that two cases appear to assume its legality. Finch versus Warriors Cement Corporation. So it's a valid procedure per that case, and also the Argenbright versus Phoenix Finance case. But we are not required in the Hellebrand case to decide the point. We now hold that the reorganization here accomplished through Section 271 and a mandatory plan of dissolution and distribution is legal. This is so because the sale of asset statutes and the merger statute are independent of one another. They are, so to speak, of equal dignity, and the framers of the reorganization plan may resort to either type of corporate mechanics to achieve the desired end. This is not an anomalous result in our corporate law. As the Vice Chancellor pointed out, the elimination of accrued dividends, though forbidden under a charter amendment from citing Keller versus Wilson, may not be accomplished by a merger. So Federal United Corporation versus Havender. So the elimination, I feel like this is the actual contention, and we just got to it, is that we're eliminating accrued dividends. It's forbidden under that, but maybe accomplished under that. I think that this is the real complaint. And in Langfelder versus Universal Laboratories, Judge Leahy commented upon the general theory of the Delaware Corporation Law that action taken pursuant to the authority of the various sections of the law constitute acts of independent legal significance, and their validity is not dependent on other sections of the Act. In support of his contentions of a de facto merger, plaintiff cites Finch and Drug Inc. versus Hunt. They are patently inapplicable. So there goes the argument. Each involved a disregard of the statutory provisions governing sales of assets. Here, it is admitted the provisions of the statutes were fully complied with. So those are distinguishable. And plaintiff concedes, as we read in his breach, that if the several steps taken in this case had been taken separately, they would have been legal. That is, he concludes that the sale of assets followed by a separate proceeding to dissolve and distribute would have been legal, even though the same result would follow. The concession exposes the weakness of his contention. To attempt to make any such distinctions between the sales under 271 would be to create uncertainty in the law and invite litigation. We are in accord with the Vice Chancellor's ruling, and the judgment below is affirmed. The next case is much longer. This is the Ferris case, so I'm going to get into this in another recording, if at all.